Okay, good afternoon.
Good afternoon, Your Honor.
Good afternoon, Your Honor.
Okay, we are scheduled here for oral arguments. Each side will have 20 minutes aside, but I do want to advise you that the arguments are being live streamed on YouTube so that the public can observe them. The other members of the panel joining me today are Judge Rick Orfinger and Judge Eric Eisnagel. Usually at this time I can tell you if they're on the right or left, but I have no idea where they are on your screen. As far as the appellate, if you wish to have me assist you in keeping time, so as far as reserving for rebuttal, let me know how much time you wish to reserve. Ms. Baker?
Yes, Your Honor. I wish to reserve 5 minutes for rebuttal.
Okay, and I assume you can see the clock on the screen as well?
Yes, Your Honor, I can.
Okay, with that, you may proceed.
Thank you, Your Honor. May it please the court, my name is Amy Baker. I am representing the appellant Principal Life Insurance Company, and Principal Life is appealing a summary judgment order that was entered in the appellee's favor, in which the trial court ruled that Principal Life had breached the terms of an insurance contract by paying the death benefit of $500,000, which was in effect at the time of the insured's death, rather than the original death benefit of $1.5 million. The trial court incorrectly determined that the adjustment request was incomplete and incorrectly determined that strict compliance with the adjustment requirements could be enforced by anyone other than Principal Life. In so doing, the trial court denied Principal Life's request for summary judgment and also subsequently denied Principal Life's motion for leave to reform the contract to be consistent with the conduct of the parties. Following that, the trial court entered final judgment in favor of the appellees and entered and awarded prejudgment interest, which is also being appealed because the award was dating back to November of 2011, 6 years before Principal Life was first put on notice of a potential breach of contract claim. Additionally, Principal Life is appealing the award of fees and costs to the appellees to the extent that fees and costs were incurred in litigating counts 1 and 2 of the complaint, which were pled against the co-defendant, and particularly before the breach of contract claim was first raised in November of 2017. I'd like to start by addressing the summary judgment argument and very briefly the facts that are pertinent to the summary judgment. And those are that on March 7, 2011, Dr. McIntosh, who was the owner and the insured of the life insurance policy at issue, removed his wife as a beneficiary of the policy following the couple's separation. And the next day, Dr. McIntosh executed an adjustment application requesting that the death benefit of the policy be reduced from $1.5 million to $500,000. He also
we're familiar with the facts of the case, counsel. Let me start out with asking you this. If this court were to agree with you on the interpretation of the agreement, if we were to agree with your interpretation of the provision that the qualifying phrase applies to the entire list, then what other issues would we need to take up? Is that sort of an issue that would that make everything else moot?
Yes, Your Honor. We believe that if the court accepts that interpretation, that would entitle Principal Life to summary judgment and would require reversal of the summary judgment in favor of the appellees, and would moot everything else.
You clearly, make a strong argument in your brief based upon sort of just grammar and the use of commas with citation to authority. Are there any other arguments you'd make based upon just interpretation of the contract that would support your position?
Yes, Your Honor. The trial court's interpretation of the contract, aside from the plain language issue, was inconsistent with an interpretation of the policy as a whole. There are several provisions in the policy that address the ability of the owner to request an increase or a decrease in the policy's face value. And there are different requirements for requesting an increase versus a decrease. The decrease only requires a written request that is signed and dated by the owner and states the amount of the face value that is desired. For an increase, there are additional.
That seems like a little bit of a conclusory statement, though. I mean, why is that?
I'm sorry, Your Honor, I didn't understand your
Well,
question.
why isn't Part D always required for a decrease?
Sure. So the application, first of all, states that, the adjustment application instructs the person who is filling it out to skip Part B of the application if it is a non-underwritten request. And that's consistent with the language of the policy that an increase needs to go through underwriting and therefore requires evidence of insurability. So the adjustment application instructs the user to fill out Part A and then skip Part B, which is the medical information, in order to request a decrease. And by skipping Part B, the health information, it moots entirely the point of Part D, because Part D is an agreement and a verification of the health information that is provided in Part B. So in addition to an interpretation requiring Part D in all circumstances being inconsistent with the language of the policy, it also would be a nullity because then Part D would not be verifying the veracity of any information. Part B wouldn't have been completed. And in addition, it would change the policy to require those who want to request simply a decrease to submit evidence of insurability the same as though they were requesting an increase. And that is not reasonable and just kind of defies.
Well, that would be, I mean, that would seem to be unnecessary, right? I mean, if they already have more coverage and they're simply asking to reduce it, providing all that information, but would there be a reason for that?
No, there wouldn't be any reason to submit health information or to verify the accuracy of health information for a decrease. That information is not reviewed outside of underwriting.
Was Part B completed in this case?
It was not, Your Honor.
Ms. Baker, let me ask you about the premiums. I know in March, the insurance company sent the insured notice that the premiums were being reduced. I believe it was from $16,000 annually to $4,000 annually. And of course, the insured died about 6 months later. And I know the payments were apparently made by drawing down on the cash value of the policy. But what does the record reflect whether notices were given that, we are hereby, taking out $1,000, reducing your actual cash value by X amount to pay for your $1,000 quarterly premium payment or anything like that? What was in the record on that?
Yes, Your Honor. There is a provision in the insurance policy itself that explains how the monthly premium charges are calculated, and that's based in part on the coverage. I didn't do the math, I apologize, and the policy does not set out the specific amount that is taken out on a monthly basis. What it sets out is the calculation for how to determine that amount, and that is in the record.
Right, but was there notice given to the insured during that 6-month period indicating, how much of premium was being taken out for that month, if you would?
Yes, Your Honor. So the data pages that issued following the reduction contained the calculation for determining the monthly charges in light of the reduction of the premiums. And in addition, the insured received monthly premium statements. However, those are not part of the record.
Okay, thank you.
Ms. Baker, on Form D, it says, I've read all the questions and answers obtained during the telephone application interview. This includes Part B. Was there a telephone application interview, or does the record reflect there was a telephone application interview for the downward modification of the insurance?
The record does not reflect that there was a telephone application interview. The only application for Part B that involved a telephone interview was when the insured initially took out the policy in 2001.
All right, thank you.
Thank you, Your Honor. And if I may, Your Honors, the problem that Principal Life sees with the ruling of the trial court is that it would change the contract, not only according to the terms of the contract, but it would be inconsistent with the intent of the parties. And that is something that the court could look to in determining what the contract was supposed to mean if there is any ambiguity. And here, all of the conduct of the parties was consistent with the reduction having been made and intended. The insured had explained why he wanted the reduction, both for the face amount and the reduction of the premium when he initially filled out the form for reducing the policy. Principal Life accepted the form, reduced the policy face value, reduced the premiums, issued the data pages to the insured reflecting that information, issued a confirmation letter to the insured reflecting the reduced premium, and thereafter, Mrs. McIntosh testified that she opened one of the statements. This was in July of 2011, approximately 3 months after the reduction had taken place. She saw that the reduction had occurred. She confronted her husband about it because she was upset, to which her husband responded that he couldn't afford the premiums, and that's why he had reduced the policy. And that is consistent with an intent by the insured to actually accomplish the reduction. Likewise, there is no evidence in the record of any of the parties notifying Principal Life that there was a mistake made, notifying Principal Life that this reduction was not what was intended. And so the court's interpretation of the contract not only changes the terms, but is inconsistent with all of the record evidence of the intent of the parties to the contract. And then we believe, Your Honors, that that conversely does entitle Principal Life to summary judgment in its favor. In addition, this claim was first asserted in November of 2017 when counsel requested leave to amend the complaint to add this breach of contract claim against Principal Life. Prior to that, there had never been a mention or an allegation or a threat of any kind that there might be any question about the legality of Principal Life's actions. All of the allegations had previously been against the activity of the agent, who was alleged to have a duty to somehow stop the insured from making this change in the first place. So because the first hint of this came more than 5 years, almost 6 years after the death benefits were paid to Mrs. McIntosh with interest, Principal Life has asserted that the statute of limitations had run and does not relate back to the claims that were pled against the co-defendant, Mr. Olstein. That is not an issue that the trial court evaluated, but we believe that that also entitles Principal Life to summary judgment in its favor. Should the court find that the insurance contract by its terms did require submission of Part D, we believe that it would be appropriate for the court to permit reformation of the contract, or at least to permit Principal Life to assert a counterclaim for reformation of the contract, because there is ample record evidence that the parties did intend this change to take place.
Let me ask you, the motion to amend to include a counterclaim for reformation occurred at 4 o'clock on a Friday before a scheduled Monday trial,
It did, Your Honor.
and the case had been pending for how long?
The case had been pending since February of 2015, so just over 2 years. However, that particular count, the breach of contract claim, had only been pending at that point for 4 or 5 months. The court permitted Mrs. McIntosh to amend her complaint to add that breach of contract claim on the eve of trial. And So trial was continued in order to permit her to allege that cause of action.
But if the new amended complaint is 4 or 5 months old, I mean, theoretically, Principal Life could have filed their counterclaim. You know, they're supposed to file an answer and a counterclaim 20 days later. Obviously, they have a right to seek leave to amend, but it's something they had all the information sufficient to file that request or that potential counterclaim at least 4 months prior. Would you agree with that?
I would agree that the claim was alleged at least 4 months prior. And the only thing I would add to that, Your Honor, is that the interpretation by the trial court that, if applicable, should be stricken was not anticipated by Principal Life. And so I suppose I would say we didn't have the foresight to think it would be necessary to allege a counterclaim for reformation at that time.
All right, you're at about 5 minutes now.
Thank you, Your Honors. I will rely on my briefing for the fee and prejudgment interest claims and reserve time for that if necessary.
Thank you.
Thank you, Your Honor. Please, the court, Patrick Gilligan for the appellees. I want to talk about the contract documents itself, and I think it's very important for the court, and I have them in my hands because there's no way to present them to them, but I think you need to read both the life insurance adjustment application and this Part D together in the operative language. I remind the court that these documents are, of course, prepared by Principal Life Insurance for their benefit, and they have a duty to make sure that they're unambiguous and clear. But in the life insurance adjustment application, it has a clause in bold when an adjustment becomes effective. And it says, I understand and agree that in applying to adjust my policy coverage, any adjustment approved by the company is effective as of the adjustment date shown on the new data pages for the policy, provided that I and the proposed insured, parent if different than me, and parent sign the Part D of this adjustment application in any amendment form, if applicable, and return the form to the company within 30 days of adjustment delivery date. The trial court pointed out the language that they drafted in their contract that says any adjustment, and they pointed that out in their summary judgment order. And then he pointed out that the language of provided that was mandatory. The court then said he thought that the term, if applicable, was ambiguous, but even if it was not ambiguous, he still thought the provided that language made it mandatory, and they had to have a Part D. He actually,
counsel, you know, we have to read all of the language and provided for if applicable, right? I mean, the provided for only is mandatory if the list of items is applicable, right?
It is.
Isn't really the real question here isn't the provided for, it seems to me. It seems to me is what does if applicable mean?
And I'm going to get to that, Your Honor, but I want to point out that in Judge Scott's summary judgment order, he actually asked counsel for principal, what does if applicable mean? And he says, counsel stated that it meant according to principal's internal policies, and Part D was only used if the applicant wanted to increase the death benefit, not reduce. There's no way for Dr. McIntosh to know what their internal policies are. And in the case we cited in our brief, it's a plurality decision from the Supreme Court, but you're not allowed to look at external sources to interpret contract. Her explanation for, counsel's explanation for—
Well, counsel, let's talk about interpretation of the contract without external sources. Then tell me, you know, just looking at the contract, why essentially you're arguing that the modifier, the phrase if applicable, applies to only the last item on the list, correct?
That's any amendment. So that's why I started off with, you've actually got to go to the Part D. And when you go to the Part D, you see that it has language that mirrors the language in the application, the adjustment application, with this one change. It says you have to sign this form, meaning the Part D form. So when you look at both the application, which it says you have to have a Part D, and then you have a Part D that says you have to sign this form in order for it to be effective. I think one by themselves, it makes it clear that you have to do that. But the if applicable language is ambiguous. It's ambiguous because the casual reader, remember, this is a contract document drafted by the insurance company, which has an obligation to make sure they have a right to impose upon their insureds their conditions in order to be insured. But what the courts have said is you have not, because you have the right to do that, and because you're dealing with people that are laymen and not generally well versed in this stuff, you've got an obligation to be unambiguous. That needs to be absolutely clear. Now, this could have been made clear, as counsel wants it to be read, if they actually said only under the circumstances that this was an increase because we need medical authorization. They could have made it crystal clear. They did not.
Mr. Gilligan, let me ask you this. Looking at the bigger picture, this is a contract and it's subject to modification. I mean, there's nothing in there that says, no party can seek modification ever. And the insured submits a request to reduce the premium, and the insurance company says, we agree. I mean, isn't that the kind of the nature of a modification? One party requests a modification, the other party says, we agree. Well, why isn't the contract modified at that time?
It is, because it is, except for the drafter of the contract said, here's how you have to do it. You have to have it's any change. They're not just saying increase or decrease. They're saying any policy.
Well, let's go a little further. If for instance, this happened, the person made a request for reduction, and then there was a letter from the insurance company says, we agree, and your premium goes down to $4,000 a year rather than $16,000. If you turn around, the insurance company kept taking out $16,000 a year, and the insured said, wait a minute, you agreed to $4,000, I agreed to reduce death benefit. Are you saying the insurance company would have a leg to stand on if they said, wait a minute, you didn't fill out all the paperwork, just because we said we agreed doesn't matter?
It's very important to both the insurance company and to the insured that they follow the policies and procedures dictated by the insurance company. Here's why it's important to the insured. He says, I want to reduce my policy from 1.5 million to $500 million. That application goes in, it comes back, and then with the Part D. And by the way, Part D is supposed to have with it what's called the adjusted data page, which shows supposedly what he did. He gets it back and he goes, wait a minute, that's not what I wanted to do. I wanted to reduce it to $1 million, not to $500,000. I see the mistake. By being able to fill out a Part D and affirming that's the change I wanted to make, they make sure there's no issues. Now, how can a mistake be made? A mistake could be made because the agent took down the information wrong on the form, which apparently happened here, and I'm going to point that out to you in a second, or because a clerk up in Iowa on behalf of a principal, while inputting the information, inputs it incorrectly. And then the insured, that was never the insured's intention. If that's the case, then an insured could be harmed greatly because of clerical errors. On the other hand, the insurance company, of course, wants to make sure, they should, make sure that they're doing exactly what their insured wants to do, that there's no problems, no clerical issues, there's no anything. And that way it protects both the insured and the insurance persons, the insured and the insurance company. Now, in this case, there's no evidence that Dr. McIntosh received back this updated data page. what Principal has stated in their brief, and it's page 1890 of the record, is they sent a letter to Dr. McIntosh on March 9th, 2011. And that letter says, we have processed a change in your premium billing, which will be effective March 15, 2011. Please verify the following information. It has the policy number, the amount of $1,000, and the frequency of of quarterly. They do not say one word in the letter. The Principal says is the letter that let Dr. McIntosh know about the adjustment to the face amount of the policy. They do not say one word about it going from 1.5 million to $500,000. There is no enclosure of these data pages that were supposed to be provided to him under their own terms and conditions. What they're saying, and they did it through affidavit, they're saying through a corporate representative that they have a policy of doing that, but he did not affirmatively say he did it. So if there had been an error, either by Dr. McIntosh or Mr. Olstein, who apparently assisted him in filling out the form, that apparently can't get corrected, even though their policies and the requirements of their contract require them to do it. Now, if you actually go to the adjustment application to show the confusion that can be engendered here, if you go to a section that starts with the paragraph number 10, right before that, it says, for underwritten adjustments, proceed to questions 10 and 11. For non-underwritten adjustments, continue to part C. 10 and 11, which aren't required, according to counsel for Principal, to reduce the policy amount, 10 and 11 are filled out. One question is asked about tobacco or nicotine usage. She says no. And then there's a number 11, a medical question asking, have you any, I'm paraphrasing, have you had any changes in your medical condition in the past 10 years? He says no. He's checked the box no. So why is Principal, through its agent, Mr. Olstein, assisting Dr. McIntosh in filling this out, why is he having him answer questions that go to this medical information where clearly above it, it says that's not even an issue. You're supposed to go to the next section and see. That demonstrates, I think, how errors occur and how things don't happen the way people want. Dr. McIntosh, at the time of his suicide and leading up to this and on this day, was in an extreme state of mental distress. He alluded to wanting the death of his wife so that he felt he would be better off if she was dead. She flees the marital home because of it. And the next day, he's at one of his best friends, his financial advisor and Principal's agent, saying, she's going to divorce me. I want to do all these things to the policy.
Well, if those facts were necessary to your argument, wouldn't you agree that summary judgment would be inappropriate? I mean, if you had to make those additional, if those additional facts are relevant, then summary to your argument, to get you over the hump, if you would, then would you agree summary judgment's inappropriate?
Judge Scott said he did not consider those facts.
Okay.
What I'm trying to point out, Your Honor, by way of example, is why it is that it is important both to the insured and the insurer that this required Part D be done. I mean, they drafted it, they said it, and I'm trying to point out an example of how it is that could protect somebody, specifically the insured, because he's in a case of extreme distress. He says that they do reconcile. So he gets back with his wife, and then had he had the opportunity to do the Part D, he could have seen it and say, you know what, I was having a bad day. I don't want to do that. But it's even important where it's a clerical error, or Mr. Olstein took it down wrong, or upon reflection. And it protects the insurance company too, because they're wanting him in that Part D to confirm this is what you want to do. And here is the data the updated data stuff, which is
Counsel,
supposed to be part of the policy.
I mean, I hear what you're arguing, and essentially you're saying, look, this would be good policy, right? For there sort of to be this backup to make sure that the insured really wanted to do this and didn't change his mind. And that, you know, maybe that would be a really good policy, but aren't we supposed to look at the language that's actually used in the agreement and interpret that language, not sort of interpret it based upon what would be a good policy or what we think would be a good policy? And so I hear what you're saying, but it seems like we ought to be talking about the language that was actually used.
Okay, and I want to get to that, and I'm going to reiterate what the language is in both the application adjustment form and in the actual Part D. It reiterates that it's any policy change. Now, principal's argument is any doesn't mean any. Then it says,
Well, no, I mean, no, counsel, their argument is that if applicable, applied to both Part D and any amendments, both items in the list. And so their argument is, look, the term, the qualifying phrase, if applicable, which is separated from the list by commas, applied to both items in the list. And do you have a response to their grammatical argument? The argument that they make is just basic grammar.
well, they get there by relying on this rule of antecedent modifiers. And the Florida Supreme Court, in I think it's the Pitzer case, rejected, once again, it's a plurality decision, but they rejected the mechanical application of that rule. They noted it was a rule of statutory construction, not a rule of contract construction. And they said, you can't just do that mechanically and say that's the outcome. And why? In a case where you have statutory construction, the court is trying to discern from poor drafting the legislative intent. Here, you're trying to discern what the parties intended, what was their mutual mind. But you have the overlay here, and by the way, Pitzer's an insurance case where they're trying to interpret language. I think it was the commas instead of if applicable. Pitzer is if required. And the case was whether or not a medical exam is required or not at a certain point in time. And the court said, if you can't figure it out, it's basically ambiguous. If it's ambiguous because the insurance company drafted it, then they essentially lose, because they have this incredible obligation to make clear to their insurers exactly what's going to happen to them or what they're going to do. In that case, that just didn't happen. And I would certainly argue, I know this is de novo review, but one of the sort of the proof of the pudding is it isn't ambiguous, but it was certainly ambiguous to the trial court. But ironically enough, I say I'm not running out of time, but ironically enough, their own expert at the fee hearing, arguing why we didn't deserve a 2.5 multiplier, said that the contract question was pretty straightforward and easy, and then we should have, wasn't a big deal. We were bound to win it because I guess presumably he thought it was ambiguous too, and it's ambiguous.
Counsel, does it matter what he thought?
Sir?
Does it matter what their expert said about the interpretation of the contract?
I mean, it does not. I said it was ironic.
Yeah, Mr. Gilligan, let me ask you, just trying to focus on your argument. Opposing counsel cited in the brief case law that says that because of where the commas were placed, et cetera, that the if applicable applies to both Part D and any amendments thereto. Do you have any case law to the contrary?
I don't have any comma where those cases. I have Pitzer, which is the Supreme Court case I just cited to you.
Right. But if there's no case on that issue, on that direct issue, was the trial court bound to follow those appellate court decisions as far as at least that determination on the meaning of that comma?
There are no appellate court decisions that do. And the closest one is what I'm talking to you about, where
Counsel, there's at least 3 in the first DCA.
well, the one I'm talking about is the Supreme Court case where they had the comma, if required, and the court was saying, looking at reading the whole policy together, it didn't make sense. And that's what I'm advocating to this court. If you read what principle says has to happen, they're saying these things have to happen, and they make sense that they have to happen.
So you're saying Pincer is binding on us?
It was a plurality decision, as I recall, Your Honor.
Are there any Supreme Court cases that actually employ the rule that we're talking about here, the grammatical rule?
You're talking about the last antecedent? There's not, I don't know. I'm aware of some cases where it's followed, certainly in the statutory construction case. I can't cite you chapter and verse, but they're typically reserved for the statutory construction, which is.
Why, if there's a Supreme Court case, why would it matter if they were interpreting the statute or a contract? Is the grammar different for the two?
Well, because the grammar rule explicitly says it's a rule of statutory construction. That's number one. Number two, it's not applied across the board, because if you have a rule of grammatical construction, and that rule of grammatical construction is at odds with a complete and fair reading of the document, you're supposed to defer to the complete and fair reading of the document. You don't mechanically apply the rule.
Yeah, I think even Singer says that, right?
Yes, sir. And that's number one. And number two, there is a difference between legislative construction and contract construction. Legislative, you're trying to figure out the legislative intent of whatever body of government is, which may be hundreds of folks that voting yay and nay, and majority has it. You're trying to figure out what their intent was. That's a different task than trying to figure out.
Well, we figure out their intent by looking at the language, right?
You do, and you can also look at subsequent pronouncements of the legislatures, other rules of construction for legislative interpretation. That's not the only one. But for contracts, you're not trying to figure out the intent of one single legislative body. There's two parties to the contract, and you're trying to determine what it was that they intended. And in that arena, the insurance company has the Florida law is clear on it. They have an overarching requirement that they be absolutely clear about what they're expecting of their.
I think the rule is that, that is the language ambiguous. It's not absolutely clear. Is it ambiguous, right? Is there a case saying that their language has to be, quote, absolutely clear?
Well, it has to be now unambiguous. And you're unambiguous if you're an insurance company, if you're absolutely clear. You can't have folks reading that and one person says, I think it means this, and the next person says, I think it means that.
All right, thank you, Mr. Gilligan.
Thank you.
Ms. Baker, I'll give you an extra minute on your time. You're muted right now.
We can't hear you.
Sorry about that habit. I'd like to address, first of all, Your Honors, the fact that Principal Life has the right to enforce strict compliance with the policy, and appellees have not contested that. They have not raised any case on that. They haven't argued that. So if there was a defect in the insured or the owner not submitting Part D, Principal Life has the right to waive that requirement and to accept the request as it is. And again, there's no argument.
Could they waive the requirement of a written request? Could they just waive that and say, we'll take an oral request over the phone, it's fine?
Sure. So yes, I think that they could. And there's case law to that effect that if there is insurance contract language that provides the request must be made in a form that is acceptable to us, that acceptable to us.
The insured wouldn't have a right to rely on the security of knowing that if anybody was ever going to make an adjustment, that it would have to be in writing instead of just somebody calling up on the phone.
I would submit that if the contract requires any modifications to be in writing, then yes, the insured should be able to rely on that. I apologize, Your Honor. I don't know if the insurance policy requires that. In this case, if it does, then yes, I agree with Your Honor.
The insurance company couldn't just waive that and say, oh, sure, we'll take it over the phone.
I would agree with that. Although that being, well, yes, I would agree with that. In this case, there was, in Mr. Gilligan's argument, he admitted that Principal Life has the right to impose requirements on the insured to sign certain paperwork along with the application. That is Principal Life's right, and it can be waived by Principal Life. A similar analogy, Your Honor, would be that if Principal Life accepted an application for an increase in coverage without accepting the medical insurance information and actually granted the increase, that would be Principal Life's decision to do. And so this is not, there's not a situation where the beneficiary has the right to enforce strict compliance with the terms of the contract. Additionally, I'd like to raise the fact that when we're grammatical construction of Part D, of the adjustment application referencing Part D and any amendment form are conjunctive. They're joined by the word and, not the word or. So even before we get to the rule of the last antecedent, there is commonly accepted grammatical interpretation. The plain meaning is that those two items would go together and that therefore applicable, if applicable, would have to apply to both. Mr. Gilligan's argument that the insurance company somehow has an obligation to keep asking if the owner intended to make the request that was written down and signed by the owner is not an obligation that I'm aware of under contract law. Certainly, Mr. Gilligan or Mrs. McIntosh have not pled mistake in entering into the contract. And that's the only basis that I'm aware of whereby a party can say if they filled out the incorrect amount for face value and that amount was actually put into effect, they could turn around and say, that was a mistake, we'd like to rescind it. But even in that situation, it would be a unilateral mistake and not a basis to change the contract. And with that, Your Honor, I have nothing further.
All right, thank you both. We'll be adjourned until our next oral argument. Thank you.
Thank you.